Speaking about jurisdiction, Popok, some weird contortions of the law by Trump-appointed judges, mostly at issue here, who have the strangest and most bizarre standing analysis in order for them to then get to the merits. I don't even think the Eighth Circuit Court of Appeals got to the merits in their order, but this massive effort by the Federalist Society lawyers, Republican Federalist Society lawyers, well, they're all Republicans in the Federalist Society, to get in front of Federalist Society judges to block Biden's student debt cancellation program. Biden's student debt cancellation program is anathema to everything the Federalist Society stands for. And what they stand for is benefits to billionaires, tax cuts to billionaires and corporations, but how dare you have a targeted debt cancellation program on people earning less than $125,000. And mostly the program is benefiting people who make less than $75,000. So we've got this case in the Northern District of Texas that went before a Trump-appointed judge, Judge Pittman, and all these cases are astroturfed, and so these right-wing groups found these two students who sued Biden administration and the Secretary of Education, basically arguing there was one student who had a commercial loan, so that student wasn't getting the benefit of the debt cancellation, and another student had only gotten $10,000 in debt cancellation, but not the full $20,000 as if they had a Pell Grant. So because they didn't get the full benefits of the program, they argued nobody should get the benefits of the program. And that was their basis for standing. And then Judge Pittman went to the merits regarding the HEROES Act, which is a 2003 law, which says in certain situations, one involving kind of military emergencies, but then it also says, or in other emergency situations, the Secretary of Education has the right to do things like targeted student debt cancellation. And so that was the statute that was invoked by the Secretary of Education in the Biden administration to implement the student debt cancellation program. And what Judge Pittman ruled is that that was an overreach of the executive branch because the student debt cancellation program was not authorized by the HEROES Act, which Pittman says that just relates to the military. And you would have to have another statute that would be implemented and passed by Congress before the Biden administration can act there. Then you go north to the Eighth Circuit Court of Appeals in a case filed in the Eastern District of Missouri originally by Republican-led states. And Nebraska is the state whose name is on the pleading, but it's a bunch of Republican-led states like Missouri and I think Tennessee and a bunch of other states. And they argued basically that by canceling the student debt, that the states would not be able to get additional tax revenue they would otherwise get if they were to tax the student debt cancellation and then the debt being canceled. And then another claim that they make is that these collection agencies affiliated with the states that collect student debt, that they're going to be hurt and therefore the states are hurt. The Eastern District of Missouri District Court judge, who was appointed by George W. Bush, found the states have no standing, because if that was the basis of standing, then states have general standing basically for everything to sue on any piece of legislation, period. Then there was appeal to the Eighth Circuit Court of Appeals, and in a very weird ruling, the Eighth Circuit Court of Appeals, first they granted a temporary injunction. Now they've granted a full injunction pending a full appeal, which could be years, right, Popok? I mean, that's not a short injunction that they issued. And they didn't even really address the standard for an injunction. Like if you look at the Eighth Circuit Court of Appeals ruling, it doesn't even talk about a probability of success on the merits by the states. Like literally the Eighth Circuit's analysis, and it was 2 Trump judges and 1 George W. Bush judge, their whole entire analysis was basically, look, this is a really big question and it could affect lots of people. So we want to preserve the status quo because students really aren't going to be hurt like this. And so because students aren't going to be hurt by the lack of the student debt cancellation program being implemented, we're just going to preserve the status quo. Like, seriously, you think students are not going to be hurt by this? And you think the states are the one who are going to be injured with their fake argument? Or that down in Texas, that the students, the fake students that have been brought in, by the way, that Myra Brown, The Intercept did or something like that. They did a great piece on who this Myra Brown is. She had debt canceled under the PPP program. She's one of the people, the students, the so-called students who the right-wing groups brought. And then when the journalist reached out to the student who sued, and the student referred the journalist to a Federalist Society right-wing group who engineered this lawsuit. But the Biden administration's fighting back, right, Popok?
Yeah, look, you got a $400 billion program here that is on hold because of what the Fifth Circuit and the Eighth Circuit have done. And the Eighth Circuit states that you were referring to that brought the case were Missouri, Nebraska, Alaska, Iowa, Kansas, and South Carolina. And you're right. If states who didn't like federal policy had standing to challenge it in court, oh, what a world of hurt we'd all be in when Red America would be able to challenge a Biden or any Democratic Congress or Democratic president's policies. So you have a filing on Friday, an interesting one. I want to talk about the procedural interest things that are interesting about it to me, and therefore hopefully will be interesting to our listeners and followers. The Eighth Circuit, which had the ruling that you talked about enjoining the continued processing of applications and forgiveness of student debt cancellation, is headed by Kavanaugh as the assistant associate justice, who's responsible for that region. The Department of Justice informed the Fifth Circuit, which has upheld Judge Pittman's ruling, and that they would be filing a Supreme Court application, not on an emergency basis. We'll talk about the difference in a minute. But they would be filing immediately an application to have the Eighth Circuit, which you've already in detail described, have their decision to stay the program overturned, to appeal it, to vacate it. They've told the Fifth Circuit that so that they know what they're doing, because the Fifth Circuit and the Eighth Circuit sort of are conjoined twins that go together here. But the filing is technically in the Eighth Circuit case. So our Solicitor General filed on Friday a 40-page brief. It is not addressed to Judge Kavanaugh because they are not doing an emergency shadow docket appeal. Let me make that clear. Right now, they've given the court basically one major way to do this on an expedited track, not through the emergency appeal process, which is decided at the first instance by the justice assigned to the Eighth Circuit, Kavanaugh. Either he makes the decision himself or he turns it over, as we've talked about in the past, to the full 9 on the bench. They didn't do that. What they've said to the Supreme Court is, you have the power to do what's called a writ of certiorari before final judgment, meaning you can make an appellate decision before there's even a final judgment on the case, similar to the standards that you outlined, Ben, for an injunction, likelihood of success on the merits, and the other factors that go into that. So they've basically invited the Supreme Court to treat this as a writ of cert before judgment on an expedited track. But we shouldn't all be waiting around for Kavanaugh to make a decision because it's not addressed to him, and they didn't do it that way for their own purposes. The attack is simple. The grounds for the appeal are simple. One, the Eighth Circuit and ultimately the Fifth Circuit is wrong. There is no Article 3 standing. We'll take it for the Eighth Circuit of all these states at all. And they go through a complete analysis of why Article 3 standing is so important, it's so limited, and why federal courts and the Supreme Court often finds that it hasn't been met, and the reasons why it hasn't been met here by these individual states. And then ultimately that the Secretary of Education's acts under the HEROES statute, HEROES law, are totally appropriate. And now we got to see what the Supreme Court is going to do next with the filing. If they're going to treat it as a writ of cert on an expedited track, we'll know that. If they reject the application or just put it into the dead letter office to be considered at a normal caucus while the Supreme Court is still in session until the start of the summer, we'll know that too. The downside is this program is mothballed until there is an ultimate decision by the Supreme Court, hopefully, to find that the Biden administration was completely right about their powers under the HERO Act, and or, which the Supreme Court often does, find there's a lack of standing so that they don't exert any judicial authority at all, which is usually the way that the Supreme Court finds the exit on a case like this. But we'll have to see when all of this is brought together. So Fifth Circuit, Eighth Circuit, the appeal is on the Eighth Circuit to the Supreme Court, impacts the Fifth Circuit. But either way, what does it mean for every taxpayer and person who's holding a student loan? You're on hold, unfortunately. You're on ice, and you got to pay your bills until the Supreme Court gets around to ruling.
You know, my expectation would be, and I don't know this, but that the Biden administration will continue the pause on student debt cancellation while they appeal. But nonetheless, the current pause is set to expire at the end of the year because it was believed that the student debt cancellation program
I agree
would
with
be
you.
implemented.
They're not going to run that program until they get clear guidance for one way or the other from the Supreme Court.
No doubt. And I think they'll continue to pause, as they have right now, the debt collection pending the ruling. But we will keep you posted there.